Gentlemen of the press, thank you for coming. The Akwa Ibom state government has carefully reviewed recent media reports suggesting that oil wells attributed to Akwa Ibom state may have been returned, and I say that in quotes, to Cross River State. Following the submission of a report, and I say that again in quotes, by a federal government interagency committee to the Revenue Mobilization, Allocation and Fiscal Commission. We consider it necessary to restate the facts clearly and authoritatively in order to prevent misinformation and deliberate distortion of constitutional realities. Firstly, the Revenue Mobilization, Allocation and Fiscal Commission has publicly clarified that what it received on the 13th of February 2026 is a draft report, not a decision on approved recommendation, and certainly not a reallocation of oil wells. The Commission has described the circulating claims as speculative and not reflective of any final position. Beyond this procedural clarification lies a more fundamental issue: the binding authority of the Supreme Court of Nigeria and the settled history of this dispute. In suit number 124/1999, Cross River State sued Akwa Ibom State over two principal matters. One, the northern non-estuarian boundary involving 24 villages of Uko, Itu, Ayadege in Itu local government area of Akwa Ibom State. And two, the southern estuarine boundary where the oil wells are located. On 24 June 2005, the Supreme Court ruled in favor of Cross River State only with respect to portions of the northern boundary. The court dismissed Cross River's claim over the estuarine southern territory where all the oil wells are situated. In its landmark pronouncement, the court made it clear that the October 10, 2002 judgment of the International Court of Justice on the land and maritime boundary between Nigeria and Cameroon had fundamentally altered Cross River State's coastal status. The court held that the ICJ decision effectively eliminated Cross River's estuarine sector, with the legal implication that Cross River State was no longer possessed a seaward boundary. Subsequently, despite Akwa Ibom State's efforts to promote peaceful engagement and preserve kinship and harmony, further litigation was initiated by Cross River State, seeking clarification on offshore entitlements. On 10th July 2012, the Supreme Court again ruled decisively in favor of Akwa Ibom State, holding that Cross River State was no longer a littoral state entitled to offshore derivation. 2, its case was founded on a legally unsustainable assumption. And 3, Akwa Ibom State's entitlement to the oil wells was fully recognized. The legal position, therefore, stands firmly established. Following the cession of Bakassi Peninsula pursuant to the 2002 ICJ judgment, Cross River State ceased to have a seaward boundary and lost its status as a littoral state for purposes of offshore oil derivation. Under Section 235 of the 1999 Constitution of the Federal Republic of Nigeria, the decisions of the Supreme Court are final and binding on all authorities and persons throughout the Federation. There is no higher court. There is no supervisory committee. There is no administrative override. No interagency committee, no technical panel, and no institutional process can alter, amend, reinterpret, or sit on appeal over a judgment of the Supreme Court. Any action inconsistent with the subsisting judgment of the Apex Court would be unconstitutional, null, and void. All the oil wells in question, whether existing or newly referenced, lie within Akwa Ibom State's recognized maritime and littoral boundaries based on established hydrographic coordinates and legally enforceable boundary adjudications. Their attribution followed due process and relied on empirical geographical data. Let it therefore be clearly stated, no oil well has been seeded. No Supreme Court judgment has been overturned. No constitutional provision has been amended. To the good people of Akwa Ibom State, we say this with utmost clarity and confidence. Your government is vigilant, engaged, and fully committed to protecting the economic interests of our state. We are following every institutional process closely, participating where required, and asserting our rights lawfully and firmly. Akwa Ibom State will not surrender its God-given resources. We will not relinquish what rightly belongs to our people under the Constitution and under binding judicial authority. Our resources are held in trust for the present and future generations, and this government will defend them responsibly, peacefully, and resolutely. We urge our citizens to remain calm, united, and confident. The foundation of our position is law. The strength of our case is geography. The shield of our rights is the Constitution of the Federal Republic of Nigeria. Thank you very much.